Most people think being polite and cooperative with police means answering every question they ask about guns, drugs, or alcohol. That instinct will destroy your case before you ever see a courtroom. I'm going to show you exactly what to say instead, and more importantly, what you must never say when officers start fishing for information. Never admit ownership or possession directly. When an officer asks, "Is this your gun?" or "Are these your drugs?" your brain screams to either deny it or explain it. Both responses are catastrophic mistakes. Here's what actually happens in that moment. The officer is creating a recorded statement. Everything you say becomes evidence. If you say yes, you've just handed them the primary element they need for a possession charge. You've established knowing possession and control. If you say no and they find your fingerprints, your DNA, or any connection to you, you've now added a false statement to police on top of the underlying charge. The legal framework here is crucial. Possession has two components: actual physical possession and constructive possession. Actual possession means it's on your person. Constructive possession means you have dominion and control over it, even if it's not touching your body. When you verbally claim ownership, you're doing the prosecutor's job for them. You're eliminating any argument about whether you knew it was there, whether you had control over it, or whether it belonged to someone else. Real case example. I represented a client where 4 people were in a vehicle. Officers found a handgun under the driver's seat. The driver immediately said, "That's not mine, I didn't know it was there." Sounds defensive but reasonable, right? Wrong. That statement proved he knew a gun was present in the vehicle. It destroyed any argument that he was unaware of the weapon. The other 3 passengers said nothing. The prosecutor couldn't prove which of the 4 people the gun belonged to. My client, the driver, was the only one charged because he was the only one who acknowledged the gun's existence in that space. What you say instead: "I'm not discussing any items or property without my attorney present." This statement asserts your Fifth Amendment right without providing any information about ownership, knowledge, or control. It doesn't help the officer, but critically, it doesn't help the prosecutor either. Never explain how something got there. Officers are trained in a technique called the explanation extraction. They'll say something like, "Help me understand how this ended up in your car," or "I just need to know how this got in your pocket." This seems like they're giving you a chance to provide an innocent explanation. They're not. They're building a knowledge and intent case against you. When you explain how something arrived in your possession or vicinity, you're providing 3 critical pieces of evidence. First, you're confirming you knew it was there. Second, you're establishing a timeline that prosecutors will use to calculate duration of possession. Third, you're creating a statement they can test and potentially disprove. Every detail you provide becomes a thread they can pull. Here's the prosecution playbook. They take your explanation and investigate every checkable fact. If you say, "My friend left it there last week," they'll subpoena your phone records, interview that friend, and check surveillance footage. When any detail doesn't align perfectly, they don't conclude their investigation was wrong. They conclude you lied, and now you're facing charges plus a credibility problem in front of a jury. I handled a case where my client found pills in his girlfriend's purse while borrowing her car. He explained this whole story to police, trying to be helpful and clear. The girlfriend denied it when questioned. My client looked like he was manufacturing a defense and blaming an innocent person. The original possession charge picked up an additional obstruction charge because the prosecutor argued he was creating false evidence. His truthful explanation became evidence of consciousness of guilt. The deeper problem with explanations is timing. You're providing this information in the worst possible circumstances. You're stressed, you're scared, you're not thinking like a lawyer. You don't know what physical evidence exists. You don't know what witnesses might say. You don't know what surveillance footage might show. You're drafting your defense strategy with 0 information and 0 time to think. No attorney would ever advise building a defense that way. What you say instead: "I'm invoking my Fifth Amendment right to remain silent, and I want my attorney." Then stop talking. Don't fill the silence. Don't explain why you're invoking it. Just stop. Never consent to searches when they ask about contraband. Here's the setup you need to recognize. An officer asks, "Do you have anything illegal in the car? Any weapons, drugs, or alcohol?" You say no. Then they immediately ask, "So you don't mind if I search then, right?" This is a psychological trap. They're using your denial as leverage to gain consent. The legal reality is this: if police had probable cause to search, they wouldn't be asking your permission. Asking for consent means they don't have legal justification to search without it. The moment you consent, you waive your Fourth Amendment protection against unreasonable searches. You cannot take that consent back once they start searching, even if they find something you didn't know was there. Consent searches are dangerous for another reason. Anything they find is admissible because you invited them to look. But also the search can expand to anywhere you gave access. If you say they can search your car, they can open every compartment, every bag, every container. They can search far more extensively than they could with many types of warrants. You've given them unlimited access. Here's what happens in court. Your attorney files a motion to suppress evidence. For a warrantless search, we can challenge whether probable cause existed. We can challenge whether the stop was legal. We can challenge the scope of the search. But if you consented, we have almost no options. The prosecutor plays a recording of you saying, "Sure, go ahead," and our suppression motion is dead. Your consent kills most of your defense options before trial even starts. I represented someone who consented to a vehicle search because he genuinely believed he had nothing illegal in the car. The officers found a small amount of marijuana in a jacket pocket in the back seat. It wasn't his jacket. His roommate had borrowed the car 2 days before. None of that mattered. He consented. They found contraband. He was charged. If he had refused consent, the officers would have needed probable cause to search. Without smelling marijuana or seeing something in plain view, they wouldn't have had it. What you say instead, "I don't consent to any searches of my person, my belongings, or my vehicle." Say this clearly. Don't add explanations. Don't say, "I don't have anything to hide, but I don't consent." That qualifier weakens your assertion and can be used against you. Just clearly refuse consent. Never answer questions about drinking or drug use timing. When officers ask, "When was the last time you smoked marijuana?" or "How much did you drink tonight?" they're not making conversation. They're establishing impairment, recent use, and patterns of behavior. Every answer you give provides evidence for a DUI charge, an impairment case, or proof of habitual use. The timing question is especially dangerous because it creates a no-win scenario. If you say you used drugs or drank recently, you're admitting to current impairment. If you say it was days or weeks ago, you're admitting to use that could still be detected in your system, and you're providing a time frame they can investigate and potentially disprove. If you say never and any test shows otherwise, you've added a false statement charge. Here's what prosecutors do with timing statements. They compare your statement to blood test results, field sobriety tests, and witness observations. In DUI cases, if you say, "I had 2 beers 3 hours ago," and your blood alcohol content is above the legal limit, the prosecutor uses your statement to prove you're minimizing your consumption. Your attempt to provide an innocent explanation becomes evidence that you're lying about your level of intoxication. For drug cases, timing matters because it affects the charges. Recent use can support possession charges even if they don't find drugs on you. It can support paraphernalia charges. It can support being under the influence charges. Your statement about when you last used gives them the foundation to pursue multiple charges based on a single admission. I had a client who told an officer he smoked marijuana the previous evening. He was honest, he wasn't currently impaired, and he thought this showed he wasn't doing anything wrong at that moment. The officer charged him with DUI based on that statement, plus some subjective observations about his eyes and his driving. We had to hire an expert witness to testify about marijuana metabolism and prove that use the night before wouldn't cause impairment the next day. That expert cost $8,000, all because of one honest answer to a timing question. What you say instead, "I'm not answering any questions about my activities or consumption without my attorney present." Don't provide timeframes. Don't provide amounts. Don't provide any information about your consumption patterns. Never let them use the "we're trying to help you" line to extract information. This is the most psychologically effective technique officers use. They'll say, "Look, we know something's going on here. If you cooperate and tell us the truth, we can work with you. But if you lie to us, we can't help you." This sounds compassionate. It sounds like they're offering you a way out. They're not. Police cannot offer you deals. They can't reduce charges. They can't guarantee leniency. Only prosecutors can make those decisions, and prosecutors won't even see your case until after you're arrested and charged. What police can do is gather evidence. When they say they're helping you, what they mean is they're helping build a case against you. The cooperation pitch comes with an implicit threat. The subtext is cooperate now or face worse consequences. But here's the legal truth. Your cooperation at the scene doesn't reduce your charges. It provides evidence for your charges. Public defenders and private attorneys both will tell you that the clients in the worst position are the ones who cooperated with police before speaking to counsel. Courts have repeatedly held that police can lie to you during investigations. They can say they have evidence they don't have. They can say witnesses identified you when no one did. They can say your friend already confessed when they haven't talked to your friend. They can promise things they can't deliver. All of this is legal. When an officer says, "Just tell me the truth and this will go easier for you," they're using a script designed to extract admissions. They're not offering a legally binding agreement. I represented a client where officers told him, "Your co-defendant already told us everything. If you don't give us your side, you're going to take the fall for all of it." He believed them. He provided a statement explaining his minimal involvement. The co-defendant had actually stayed silent. My client's statement became the primary evidence in the case. His cooperation resulted in him being the only one with a recorded confession. He received the harsher sentence because the prosecution had stronger evidence against him. What you say instead? "I understand you have a job to do, but I'm not making any statements without my attorney present." This acknowledges them professionally without falling for the cooperation trap. Never answer the question about whose drugs or guns they are if you're in a group. Multiple person scenarios are where the most mistakes happen. Officers find contraband in a car with 4 people or in a house with 3 people. They ask, "Whose is this?" Everyone panics. Someone claims it to protect the others, or someone blames another person, or everyone denies knowledge. All of these responses create evidence. If you claim ownership to protect someone else, you've confessed to a crime you might not have committed. You think you're being noble, you're actually creating a case the prosecutor doesn't have to work for. Courts don't let you take back confessions just because you later say you were protecting someone. Your statement stands as evidence regardless of your motivation. If you blame another person in the group, you create 2 problems. First, if you're wrong or if they can prove you had equal access and control, you look like you're lying and deflecting blame. Second, you've damaged any potential unified defense. Defense attorneys representing multiple defendants can sometimes argue that the prosecution can't prove which person possessed the contraband. When you point fingers, you destroy that strategy. If everyone denies knowledge, that actually can work in your favor legally, but only if you stay silent. When everyone says, "I don't know anything about that," police have no statements to work with and prosecutors have to prove possession through circumstantial evidence alone. But if even one person provides a statement, that breaks the united front and gives prosecutors leverage. Here's a real scenario I handled. 4 people in a vehicle, cocaine found under a seat. 3 people stayed completely silent. One person said, "I've never seen that before, maybe it's from whoever had the car before." That person thought they were giving an innocent explanation. That statement proved they saw the cocaine and were aware of its location, establishing knowledge. The other 3 could argue they never saw it and didn't know it was there. The person who spoke was the only one convicted. The prosecution strategy in group possession cases is to isolate someone. They look for who spoke, who seemed nervous, who had the most access. Your statement gives them that isolation target. Silence from everyone means they have to prove their case through physical evidence, which is much harder. What you say instead? Absolutely nothing. Don't claim it, don't deny it, don't explain it. Say, "I'm invoking my right to remain silent," and maintain that position even when others are talking. Never answer questions about whether you know something is illegal. Officers will ask, "You know it's illegal to carry a gun without a permit, right?" Or, "You know you can't have open alcohol in your vehicle, right?" These seem like rhetorical questions or just statements of fact. They're not. They're establishing criminal intent and knowledge, which are elements of many offenses. For weapons charges, knowledge that carrying without a permit is illegal can be an element of the offense. Your acknowledgement that you understand the law can be used to prove you intentionally violated it, which can mean the difference between a misdemeanor and a felony charge in many jurisdictions. For drug offenses, knowledge that a substance is illegal matters for intent to possess charges. If you acknowledge you know marijuana is illegal in your state, and they find marijuana in your car, your statement helps prove you knowingly possessed a controlled substance. Without that statement, you could potentially argue you didn't know what the substance was or didn't know it was illegal. For alcohol offenses, especially involving minors, your acknowledgement that you know the age restrictions can elevate charges. Providing alcohol to minors with knowledge that it's illegal is a more serious offense than doing so without that knowledge in some states. The legal principle here is called mens rea, which means guilty mind. For many crimes, prosecutors have to prove you had criminal intent, that you knew what you were doing was wrong. When you answer these questions, you're handing them evidence of your mental state. You're proving you had the knowledge component of criminal intent. I represented a client charged with unlawful possession of a weapon. The officer asked him, "You know you need a permit to carry that, right?" And he said, "Yes, I just haven't gotten around to applying for it." That statement proved he knew he was violating the law. It eliminated any argument that he misunderstood the permit requirements or believed he was in compliance. His case went from a potential dismissal on technical grounds to a guaranteed conviction because he established his knowledge of the illegality. What you say instead? "I'm not answering any questions." Don't confirm or deny your knowledge of any laws. Don't provide any information about your understanding of legal requirements. Your silence cannot be used as evidence of guilt in a criminal trial. Your statements can be and will be used against you. Every single word you say to police is a potential piece of evidence for the prosecution. There is no statement you can make that will prevent your arrest if officers have decided to arrest you. There is no explanation that will convince them to let you go if they've found contraband. Here's what you need to understand about police investigations. Officers are gathering evidence to support charges. They're not investigating whether you're innocent. Once they've found guns, drugs, or alcohol in a questionable context, they're building a case. Your job is not not to help them build that case. Your job is to preserve your legal rights so your attorney has options to defend you. The prosecution will use every statement you make. They'll play recordings in court. They'll have officers testify about what you said. They'll use your words to establish elements of offenses, to prove intent, to demonstrate knowledge, to show consciousness of guilt. Defense attorneys can't suppress your voluntary statements. We can't keep out evidence you provided willingly. You tie our hands when you speak without counsel. This isn't about being difficult or uncooperative in a problematic way. This is about understanding the legal system and how it actually works. Police officers are trained to gather evidence. Prosecutors are trained to use that evidence to convict. Defense attorneys are trained to protect your rights and create reasonable doubt. But we can only work with what we have. Every statement you make without counsel limits what we can do to help you. Remember this, you will never talk yourself out of an arrest by answering questions about guns, drugs, or alcohol. If they have enough evidence to arrest you, they will. If they don't have enough evidence, your statements might give them what they need. The only tactical move is silence. Invoke your Fifth Amendment right clearly, request an attorney, and stop talking. That's not suspicious. That's smart. That's what every lawyer would do in the same situation, and it's what every lawyer tells their own family members to do. Your words in that moment have consequences that last through your entire case. Protect yourself by staying silent. If you enjoyed this video, check out our other awesome videos on the channel. Thanks for watching, and we'll see you next time.